What 501c3 actually is? 501c3 is a federal tax classification created by the IRS. It means the IRS has recognized the organization as organized for charitable, religious, educational, or scientific purposes, and eligible for federal income tax exemption, and eligible to receive tax-deductible donations. Only the IRS can grant or revoke 501c3 status. States do not grant 501c3 status. What Florida does and does not do. Florida does several separate things: a corporate existence, division of corporations, SUMBIS. Florida creates legal entities, non-profit corporation, for-profit corporation, LLC, etc. This is just legal existence, not tax status. When you see a Florida non-profit record that says something like non-profit corporation to 501c3, that usually means the organization claims or represents 501c3. Florida is not granting that status. It is just recording what the organization says it is. B. Florida Department of Revenue state tax exemption. Florida has its own tax system: sales tax, use tax, reemployment tax, etc. Florida may require a non-profit to apply separately for Florida sales tax exemption. Other state tax exemptions. Florida often asks, are you a 501c3 with the IRS? If yes, they may grant state-level tax exemptions based on that. But again, Florida is recognizing IRS status, not creating it. If the organization solicits donations, Florida usually requires registration as a charitable organization. This is consumer protection / fundraising oversight, not tax status. They may list IRS status 501c3. Again, this is a representation or verification, not the source of the status. Why you see 501c3 in Florida records? Because Florida agencies often mirror or display the IRS classification, or the organization self-reports it, or Florida has verified it against IRS data. But Florida is not the authority that grants it. Think of Florida as saying, this energy claims to be, is recognized as a 501c3 by the IRS. For the only authoritative source, the only legally controlling source is the IRS determination letter, or the IRS tax-exempt organization search database. If the IRS database says, not tax-exempt or revoked or never recognized, then the organization is not a 501c3, no matter what Florida's website says. Howcourtswork. You can see Florida listing, 501c3, IRS listing, revoked or never determined. This happens because Florida records aren't automatically updated. The organization changed status. The organization lied or misunderstood. The exemption was revoked. The entity never actually got IRS approval. The Florida record is just old or unverified. Thinking layers. Florida creates the entity. IRS grants or denies tax-exempt status. Florida may acknowledge or rely on that IRS status for state purposes. Florida cannot create or fix IRS status. The critical legal takeaway. If the IRS does not recognize the entity's 501c3, then does not one in Florida's website says this. If someone is soliciting donations claiming 501c3 status without valid IRS recognition, that can be fraud. Donor tax deductions depend on IRS status, not Florida labels. Grant eligibility depends on IRS status. Some legal protections depend on real tax-exempt status. Misrepresentation can carry civil and sometimes criminal consequences. NotALawyer. One sentence. Florida can record, rely on, or display 501c3 status, but only the IRS can grant it, and only the IRS determines whether it truly exists.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.